Jay, good evening. What's your question?
Good evening, Daniel. Yes, my question this evening is regarding employment law and more importantly, trade union negotiations. So I work for a major UK international airport, who I'm not going to mention, and as a result of the COVID-19 crisis and pandemic, they are looking at making permanent pay cuts. Now, they've been in meaningful consultation with the unions for quite some months. The negotiations are still underway. However, over the last couple of meetings that they've had, during the adjournment, they've made unlawful comms to staff by saying that we are going to start individual consultation. Now, rightfully so, the unions have said, well, hold on a minute, we are still in meaningful consultation. This is clearly a breach of the trade union and companies' dialogue. And I personally have received a letter today, as of many others across the business, stating that in the next week or so I shall be invited to a one-to-one consultation with the business and discuss my options. The options are a buyback for my existing contract, significantly reducing my pay by about 20.8%. It could be up to 36%. I'm personally 20.8%. And there are options that I have in either getting the agreed buyback amount, which is twice the difference in my pay.
Okay, Jay, I don't think we need to go into the detail of the exact offers. I'm assuming you're a trade union representative?
No, I'm a member of the trade union, not a representative. No, I just want to know, is there any legal grounds whilst there's a ballot to be held, which is due to close on the 5th of next month, in the company? Is there any lawful or unlawful reasoning behind this?
Okay, this is a great question, Jay, and I'm going to give you a typical lawyer's answer, which is yes and no. Let me tell you why. There's the law that controls all the issues of unions negotiating with employers. It's called the Trade Union Labour Relation Consolidation Act. And when one of the sections in there says that employers aren't allowed to offer incentives to workers to influence their relationship with the union and avoid the collective union negotiation process. But there's a case that's going through the courts at the moment. It's just been to the Court of Appeal, which is the second highest court, called Coastal and Dunkley. And that case says that the law against employers offering incentives to employees to opt out of union negotiations only applies to big-scale things, such as saying to an employee, I'll give you this money, I'll give you this offer, if you agree not to be bound permanently or generally by collective agreements. But the Court of Appeal said that as a one-off, which is what seems to be happening here, as a one-off, it is okay for an employer to say, we haven't been able to reach an agreement with the union, so we're going to make you an offer directly. Now, that case is going to the Supreme Court because a lot of people think it's wrongly decided, and it's going to be heard, or it has been heard, and we're waiting for a decision hopefully later this year. So that, Jay, is why I'm afraid I'm giving you the really unclear answer of yes and no. The Court of Appeal has said the employers are allowed to do this, but a lot of people think the Supreme Court's going to overturn that in the next few months and say, no, it's illegal. Does that help, Jay?
It does. So just following on from that, a very quick point is, if people are obviously between a rock and a hard place and they run the risk of losing their job, so they are forced to sign this through no fault of their own, under duress or however you want to put it, where do we stand in the future with, if this is appealed later on by the unions, would that be a case of just giving a financial payment or reinstating the existing contracts? Where do we stand with things like that?
Well, it would be a claim that could be brought in the Employment Tribunal for compensation, financial compensation, for offering you what's called an unlawful inducement to opt out of collective bargaining. But if you sign the contract, then it will be binding. The possibility, of course, is that the union might then call industrial action to get the old contracts or whatever was agreed for those who didn't sign the varied contract into place for everybody who did sign the varied contract. But the contract that you sign, if you choose to do so, won't be ripped up. You just might be given compensation by a trade union if the Supreme Court reverses the Court of Appeal for an unlawful inducement to avoid collective bargaining.
Excellent. Thank you very much.
Good. Jay, thank you very much. John is in Bairstow. John, good evening. What's your question?